Right. Good afternoon to you, colleagues, ladies and gentlemen, joining this call this very wonderful Tuesday afternoon. I hope you're keeping safe and well wherever you are. East Africa right now is at an interesting place because in some areas it's really, really cold, and in other parts it's really hot and the sun is scorching hot. But wherever you're joining us from, very good afternoon from the East Africa Law Society. We are extremely elated to host you today, yet for another capacity building session. One of our mandates as a society is to promote professional development. So we never stop learning. We are always learning, and we are glad to always have a pool of experts come in every week to share with us their expertise. These are heroes and titans in the various fields of practice always put aside their time to come and share with us their knowledge, their experiences, and expertise. And this afternoon is such a wonderful afternoon because we discuss a very important, emerging, and interesting area of taxation. And today we discuss real estate tax, and we want to understand what are the rules and game-changing opportunities that lawyers have in this area of practice. And today, in this afternoon, we are really privileged to have a panel of distinguished ladies and gentlemen who have joined us from all spheres of life. We have speakers from academia. We have renowned tax experts, Dr. Leila Latif, Mr. Patrick Chege, Mr. Cephas Birungi, and we have the taxman himself, Mr. Tony Kalunji, from the Uganda Revenue Authority. They'll be introduced later on, but right now it's my singular honor to invite and introduce a friend and sister of mine, Miss Rachel Kembabazi, a senior associate at SM and Co Advocates, which is formerly Shunubi Musoke Advocates. And Rachel is a senior associate at the firm, and she's quite skilled in areas of corporate tax, banking, and finance department. She also enjoys employment law and dispute resolution. She has a proven track record. She's a member of our committee. She is a, a lady that was awarded the Rising Star Award by Africa Legal Awards in 2019 and 2020 and 2021, respectively. And we are waiting for the next award that Rachel will get because she's always winning big. So Rachel will be moderating this session this afternoon. And Rachel, it's my singular honor to invite you to take it on from here. We are once again thrilled to host you and look forward to a very wonderful session. You have us now for the next 2 hours. 2 hours until it blocks 4 p.m. So over to you, Rachel.
Thank you, Gabriel. Good afternoon, colleagues. Good afternoon, East Africa. I hope you can hear me loud and clear. Yes.
Yes, we can.
Yes, it's an honor to be here again and to moderate this session. I'm particularly excited by the learning and development that is continuous across the region, and I'm always happy to participate to learn from the distinguished professionals across the board. So I'll not take so much time. We usually like to keep time, and it's sad that just my introduction took 5 minutes, but I'll try to be very fast and try to make sure that we at least keep time, because we are here to discuss tax and generate revenues, and that's all time for us to make money and comply. So yes, I just thought that before I start our session, this comes in actually quite handy. It comes at a very it's at a very good time, because in Uganda, for instance, we just had our budget read. This was read last week. And it was very exciting to know that part of our revenues this year, maybe just so to say, In Uganda, we have a budget that we're expecting to raise, I think, 72 trillion. And that's what's going to cover the budget for this year. And part of that budget is supposed to come from the tax revenues. And at least I'm happy to report that tax is expected to contribute at least 33 trillion out of 37 that is expected to come from domestic revenue. Please note that we've also experienced a bit of a decline in external sources of revenue for Uganda. So we are looking at mostly domestic revenue, at least for this year. And what a timely session we are having today to look at how we can leverage both in our economy and amongst ourselves to ensure that we both plug in to actually raise this revenue. But it's not all, hope is not all lost. And that's why we're here today as we focus on real estate, as we focus on the digital economy and taxation of it, and to see how we can also be relevant and position ourselves strategically as professionals to continue encouraging our clients or advising them to actually be tax compliant or to raise some of these revenues. So without further ado, please allow me to welcome our first panelists. I usually prefer to introduce our panelists as they present so that we know who is speaking to us when. As Gabriel said, this panel is quite distinguished with the professionals that have quite a myriad of experiences. We have people that have worked with tax revenues and some tax revenue authorities, and some are still working with them. We have some that come from the academia, from policy making and strategy. So allow me to introduce our first panelist, being Ms. Leila Latif. And Ms. Leila is the Chief Executive at Latif and Company Advocates. She specializes in corporate law, transaction advisory, and tax law. And what's quite catchy about Ms. Leila is that she's a seasoned lawyer, academic, and policy strategist. She's had the privilege of working with the World Bank and has advised on several emerging tax regimes and digital economies. So allow me welcome Leila, and she's going to cover our very first topic on the recent developments on what's actually happening across the region. So she's going to look at the recent tax developments in Uganda, in Kenya, in Tanzania. Please don't ask me how she's able to do this, but it's because she's qualified too. Ms. Leila, you're welcome. Please take us away.
Thank you very much. Greatly appreciate your introduction. And it's always a pleasure to support the conversations that we have through the East Africa Law Society. So I'm going to, great. Now, I think for me to start off this conversation is to point out that as legal practitioners, we stand at a remarkable intersection, right? From the way we've seen traditional property law evolve to the way in which digitalization has now caused a revolutionary approach to the way we understand land, property, real estate taxation. So in today's webinar, I think I'm going to be exploring how Kenya, Uganda, and Rwanda are reshaping the very foundations of property taxation, the property transactions, the tax frameworks that are coming about as a form of reform measure in these countries, and also looking at legal compliance in ways that really demand our immediate attention and adaptation as well. So to begin with, I think the first most important question that we have to ask ourselves is that why does this conversation matter to every lawyer, who has dialed in today? And for me, I'd probably start by saying it's because whether you are advising a multinational corporation on cross-border property investments, whether you're representing a family trust in succession planning or structuring a real estate development project, the changes unfolding across these jurisdictions do fundamentally alter how we practice property law. So I want to begin with a striking observation, okay? On this slide, you're seeing 3 countries that have been projected. Now, while we often speak of East African integration, Kenya, Uganda, and Rwanda, they've chosen remarkably different paths to modernize their property and tax systems as well. So forget about regional harmonization. We're always taking nationalistic approaches in how we want to protect our fiscal space and generate more in terms of domestic revenue mobilization. If we're going to think about Kenya, we're actually witnessing the maturation of a sophisticated tax regime through our 2025 finance bill, which balances revenue generation with economic development incentives. So you see, Kenya has moved beyond the historical volatility of property taxation to create a comprehensive framework that extends from capital gains and stamp duty to VAT and also excise implications on construction materials, which are really key for our property regime. Now, this isn't merely tax policy, it's economic engineering that affects every property transaction we handle. Then we turn to Uganda, right? And the Ugandans are in the house, also on panel. And Uganda presents us with an integrated approach to capital gains taxation that eliminates separate capital gains regime entirely. It incorporates property gains into business income at a substantial 30% rate. And more significantly, Uganda also has this deemed realization provisions, which create immediate tax consequences for corporate ownership changes which exceed 50%, which I really think is a trap that can devastate unprepared property holding structures. And then Rwanda, it's a digital pioneer. That's how I see it. It's got a phenomenal digital platform called Irembo, and you should take time to look at that platform, which is, available online. And when you think about Rwanda, it has embarked on perhaps the most ambitious digital transformation in property administration anywhere in Africa. So from January 2023, Rwanda eliminated physical land titles entirely, and they implement electronic certificates that can be issued instantly upon approval. They've got their one-step, one-day commercial property transfer system, which basically challenges everything we thought we knew about transaction timelines, right? So over the next 15 minutes or so, I will take you through each country's evolving approach through the proposed reforms on property transactions, what their legal implications are, the compliance concerns that we should have, and also some key points for us in practice. And of course, I'm going to start off with Kenya. And my focus is going to be on the proposals contained in the Finance Bill 2025. Now, we're going to start off with CGT, capital gains tax. So the Finance Bill that we have, right, it maintains the 15% capital gains tax rate on property transfers as a final tax. But at the same time, it's come up with enhanced exemptions for the Nairobi International Financial Center's certified investments. Now, if we're to think of the legal implications of this, then the retention of the 15% rate, it provides certainty for property transactions, which eliminates the historical volatility of capital gains tax policy in Kenya, because we've been moving from 5% to 15%. There've been proposals to even push it further up, but now this finance bill creates for us that certainty that is very much needed in terms of ensuring that businesses are aligned with the legal practice that is emanating from the tax design of our government. Also, the final tax designation, which CGT is referred to as at 15%, it actually means no additional income tax liability arises from property gains, which simplifies compliance as well for the Kenya Revenue Administration. But as lawyers, we must note that, in Nairobi, we've got the Nairobi International Financial Center that operates as a tax haven or an offshore center to allow for a lot of preferential tax treatment to businesses, right? And these businesses could be corporations, trusts, even conduits and intermediaries across the, global tax framework. But we have the NIFC in Kenya, but it kind of presents an exemption on capital gains tax as well. And this exemption is that instead of the 15% that is payable, onshore in Kenya, on the NIFC, the CGT has been reduced to 5%, but it's only reduced for qualifying investments which exceed 3 billion Kenya shillings that have been held over 5 years. So generally in Kenya, our CGT creates a two-tier system which requires careful structuring for high-value transactions. So as a result, what we have to be focused on is on the three compliance considerations insofar as CGT is concerned. The first one is property valuations become critical for establishing baseline costs. That's what we need to think of as lawyers. Secondly, the documentation of holding periods is very essential for NIFC benefits to kick in, right? It's got to have the 5-year threshold. And then the third part is that the transactions also must be structured to qualify for applicable exemptions. Then we've also got the enhanced property transfer exemptions that have been provided for in the first schedule, paragraph 36F and G, and also the 8th schedule, paragraph 62H of the finance bill. Now, this finance bill, what it's proposing is that it's proposing for an extension of estate administration transfer periods and explicit exemption for transfers into registered family trusts. Now, this extended time frame for estate transfers, which is basically 2 years from death with additional time for court proceedings, it addresses practical challenges in estate administration. The family trust exemption, it also presents a significant development which allows tax-efficient estate planning structures for us to be able to advise clients on. And this creates opportunities for sophisticated wealth preservation strategies and at the same time maintaining family control over property assets. Okay, so when it comes to compliance, what we must consider are, firstly, that estate practitioners must document court proceedings to justify extended periods so that you can look for exemption around the CGT. Secondly, the family trust structures would also require careful drafting to ensure a registered status so that on inheritance, the CGT does not become applicable. And then also the timing of transfers become crucial for exemption quantification. Then we've also got the 8th schedule, paragraph 62H, which is critical because here the bill proposes comprehensive exemptions for transfers between spouses, even former spouses in divorce settlements, immediate family members, and also to companies with 100% spousal or family shareholding, right? These are the proposals insofar as CGT is concerned in Kenya. Through this bill, if it passes, it becomes law. Now, this provision under the 8th schedule, it significantly expands family transfer protections. The government, which is a good thing, is recognizing that family restructuring should not trigger tax consequences, okay? And the inclusion of company transfers where spouses or even immediate family members holding 100% shareholding allows for sophisticated family business structures without tax penalties. But remember, the word immediate family, the definition for that is actually limited to children of spouses. So therefore, it may exclude other relatives commonly involved in the African family structures. So for us as lawyers, when it comes to compliance, our task then is to diligently consider when it comes to divorce settlements, they must be properly documented as bona fide. Because we're going to see cases, as not so much in Kenya, but when you go to the global north, you get to see a lot of divorce settlements, which are basically structured in a way to avoid tax obligations. And that's why in the finance bill, it's a consideration that if you want to be able to, exempt yourself from CGT when it comes to property settlement, you've got to make sure that that divorce settlement is actually bona fide. It's a tax protection. And then also, you've got to diligently consider company shareholding structures to confirm and verify that indeed the shareholders are 100% family, right? So the family ownership criteria is really significant to be able to apply for this exemption. And also when advising on succession planning, consider the benefits from advanced structuring to qualify for exemptions. Moving forward, we're also seeing different structures around property taxation within the finance bill. And we're seeing this from the perspective of stamp duty on one hand, and also this withholding tax provision. Now, the kind of reforms that have been proposed insofar as stamp duty is concerned, we've got an amendment that is proposed to Section 117R of the Stamp Duty Act. Now, this section is actually proposing new exemptions that are being provided for property transfers by companies to shareholders during internal reorganization, okay? Provided that the transfers maintain proportional shareholding and involve subsidiary shares. Now, this is a careful provision to prevent aggressive tax avoidance and even tax evasion that may occur in the way in which the company wants to arrange its restructuring affairs. Okay, but it's also considering the fact that if the company is internally reorganizing, that reorganization should not elicit a tax obligation. So it's a really important provision that we're having that also brings about simplicity for business and also attracts businesses to come and want to invest in the country as well. Now, this provision 117, it also facilitates corporate restructuring without stamp duty penalties. It enables efficient business reorganization, which is fundamental. Now, the proportional shareholding requirement, it prevents selective distributions that could circumvent normal dividend taxation. And the subsidiary share requirement, it suggests the exemption targets group restructuring rather than simple property distributions. So what does this mean for lawyers, right? We've got to be really careful when conducting our compliance checks when it comes to stamp duty exemptions for internal company restructuring. We've got to be cautious on applying this exemption. And what we need to be cautious about is, first of all, we've got to really confirm and verify that the reorganization plans that the company is making, it must maintain exact shareholding proportions. Any change will trigger stamp duty. Then we've also got to write our legal opinions in such a way to really establish and justify that the restructuring is an internal reorganization and not just a restructuring to be able to shed off shares for another investor, right? And you're trying to look at this section 111 as a way in which to avoid the tax liability. So we've got to be very careful in how we also provide legal advice to these companies so that we are not encouraging aggressive tax stripping. And then, of course, the documentation that the company must produce, it must clearly demonstrate the subsidiary relationships between the company and its subsidiary to confirm that indeed it's an internal reorganization which doesn't trigger the stamp duty. Now, there's also section 117 LA and O, which provides for stamp duty exemptions for first-time home purchases, but under the affordable housing schemes and transfers from developers to the National Housing Corporation. It's a public gift, a sort of a public incentive. And these provisions, they operationalize government housing policy through tax incentives. It makes home ownership in Kenya more accessible. So it's a tax-friendly regime for first-time owners, provided that they're purchasing the home from the affordable government housing scheme that is being provided currently under the Ruto administration, yeah? And then also the developer to corporation transfer exemption, it kind of suggests a structured approach to affordable housing delivery. But what I want us to note as lawyers practicing in Kenya is that the first-time homeowner definition, it actually requires clarification in practice. Because think of a scenario where two parents purchase a home, but then instead of having themselves listed as the owners of the home, they list their minors or even their teenagers as the homeowners. Now, in the future, if these teenagers now want to go and purchase their own home, will they qualify as first-time homeowners? Right? So these are things that we also need to clarify as part of our doctrinal analysis of the finance bill. Then, of course, there's also section 35(3)J and the third schedule, paragraph 5JA, which provides for withholding taxation, which is significantly important when it comes to property taxation. Because here, the bill is proposing to maintain a 7.5% withholding tax on rental income for residents, but with enhanced collection mechanisms through appointed agents, right? So now this provision of having the appointed agent system, it's actually shifting collection responsibility to intermediaries. Probably there would likely be property managers and estate agents. But this is important because it's going to improve compliance, but at the same time create new obligations for property service providers. I really think that this represents a move towards source-based collection, which is going to reduce direct enforcement costs for the Kenya Revenue Authority, but at the same time increase compliance rates. So it's an effective way to see an increase in tax mobilization through the approach of WHT in the form of rental income taxation. So as lawyers, what we need to focus on is to ensure that property managers have been registered as appointed agents. That's really significant. But then there's also Section 35(1)(c), which relates to non-resident withholding. And here, the bill is proposing 30% withholding tax on rental income that is paid to non-residents, with specific exemptions only for aircraft and rolling stock for corporations, okay? Now, what we see with this particular high tax rate is that it kind of, I think, reflects policy preferences for domestic property ownership, but at the same time, it's also recognizing international investment needs. So what we are seeing insofar as rental income taxation for non-residents is concerned, they've got some exemptions. And these exemptions are only for specific assets, right? Which suggests recognition of specialized financing arrangements only in aviation and transport sectors. Now, when we're advising clients who are sourcing income out of Kenya, then as lawyers, I think we need to conduct due diligence on beneficiary residents, because this is critical to know what tax rate to then apply. Is it 7.5 for a resident, or is it 30% if the client is a non-resident? Very importantly, you also need to familiarize yourself with the double tax treaty between Kenya and the non-resident who's living in a state that has a tax treaty with the country, because sometimes the tax treaty could subject both the government not to apply capital gains tax. And that's going to have implications on the Income Tax Act for Kenya that proposes the application of rental income tax. So it's really important whenever you have a foreigner investing in your country to be able to look at the double tax treaty to see if there are going to be any legal implications that might counter national legislation being applicable. So let's now move on to consider the implications of digitalization. I think it's a fantastic approach to seeing how the economy is evolving. There's a lot to talk about digital economy taxation, and we have a fantastic panelist who will discuss this. Now, Section 2 of the Excise Duty Act within the finance bill has been proposed to be amended by introducing a definition of digital marketplace, right? And it's defined as an online platform which enables users to sell goods or provide services to other users. Now, this has legal implications. And the legal implications are that property rental platforms, you think about Booking.com, Airbnb, as well as real estate marketplaces, they may now fall under excise duty provisions simply because of this definition that is being introduced. Now, online property rental services, it could actually attract services. They could attract excise duty if they're provided through digital marketplaces. But this is also going to create new compliance obligations for property technology companies. What this means is that property rental platforms will require excise duty assessment. Digital property management services will need compliance review, and cross-border property platforms may then face excise obligations. Okay, so this is it insofar as Kenya is concerned in terms of looking at the proposed reforms that are going to impact the real estate market. Now, let's turn to Uganda. And for Uganda, I only want to explain its CGT and rental income approach. I think on CGT, it is pretty straightforward. Uganda does not impose a separate capital gains tax. Instead, capital gains are included in and taxed together with business income at the standard corporate rate of 30%. And this applies to disposals of non-depreciable business assets, I think, as well as share sales. Now, in my view, Uganda's integrated approach, it kind of, creates several significant consequences for property transactions. You see, unlike jurisdictions with separate capital gains regime like we have in Kenya, Rwanda doesn't have one. Property gains receive no preferential treatment and they are taxed at the full corporate rate. Now, this removes the complexity of separate capital gains calculations, but potentially it increases the tax burden on property disposals. And the classification of property as business assets then becomes really critical, as only business-related property disposals attract this investment. Right? So the tax design then starts to get a bit complicated if you're going to be looking at the cross-border implications of this. But then there is also the 50% ownership change rule that applies in Uganda. Okay, what I mean by this is that a change in ownership of 50% or more in a Uganda-located company, it triggers deemed realization of all assets and liabilities at market value immediately before the ownership change. Now, you see, this provision, it actually creates substantial tax liabilities on corporate restructuring, and it presents significant challenges for property holding companies. Now, you compare this to what I was talking about Kenya, and Kenya basically exempting companies that are beginning to conduct internal reorganization. The same does not apply here, apparently. Okay, it occurs regardless of whether actual disposals take place, which creates immediate tax obligations that may not correspond to cash generation. This becomes really problematic for businesses. And what this means is that it effectively prevents tax-free corporate reorganizations, which involve property companies, and it requires careful structuring of ownership changes. So what we need to be clear on is that the 50% threshold is actually cumulative, and it can be triggered by multiple smaller transactions. So really be careful about that. And then the provisions capture both direct and indirect ownership changes as well. So even these things about beneficial ownership come to play in this corporate structure that we're looking at insofar as Uganda is concerned. I think when it comes to advising clients, please, I think you would probably want to consider that ownership transfer structures, they must be designed to stay below 50% threshold, right? That's a tax move. And then property valuations should be obtained before any ownership changes. And then cash flow planning must account for deemed realization tax without corresponding cash receipts. And then also consider asset distributions before ownership changes to minimize deemed realization impact. Now, more importantly, is also Uganda's reformed rental income taxation framework. It's very interesting. It's a dual.
And I think we keep losing you. You keep breaking the beats, and I think we've lost you now. Can you hear us? Hel, are you there? Can you hear us? I think we've lost you.
The flat rate system, it also simplifies compliance for individual property owners, while the expense restriction, it prevents aggressive deduction strategies, right? So the threshold of this 2.82 million Uganda shilling, it provides relief only for small-scale property owners, but it captures most serious property investors, which is actually an excellent, tax proposal. And the inability to deduct expenses means that individuals bear tax on gross rental income, which potentially creates cash flow challenges where substantial maintenance or financing costs arrive. So it's a tad bit unfair for individuals as you compare it to companies, because for companies, the tax rate is 30%.
Leila, we keep losing you. I think we've lost you again. I'm not sure I could be the only one though.
Closable, and they're also non-transferable. They cannot be carried forward to the next year. Yes, I'm about to conclude. I just have.
So you're good, Leila. Please go on. It's just that I keep losing you. I don't know if it's just the connection on my end. Leila, can you hear us?
I think we've lost Dr. Leila.
Yeah,
So-
completely.
Yeah.
I thought it was just a glitch on my end, but I'll just quickly reach out. Gabriel probably could too. And I figured she may not have noticed that she dropped off. Okay, as we wait for Dr. Leila to come back on, please prepare your questions for anyone that might have questions, and we'll take these at the very end. But please keep them coming. You could either raise your hand at the end of the session or just send a message in the chat box so that we can just take them up.
Hello, sorry, I think my internet booted me out. Do I still have time or I'm done?
Yeah, you're right. We'll just give you 5 minutes to just close since you lost a bit of it.
Thank you. But I think I did manage to finish on Uganda. The only thing I want to now say is on Rwanda. I hope you can see the slide.
Yes, we can see it. If you could just, yeah, that poster is on.
So I only have one slide for Rwanda, and it's the image of Irembo, its digital platform, which is like a fantastic digital platform where all government services are provided. And this is where the property regime has become so simple and uncomplicated. And I'm going to just speak about that very quickly. Now, Rwanda happens to be very exciting in its approach to land and property transactions. These guys have created 100% digital land registry, which means that they issue electronic certificates, and they call them e-title, electronic title, which basically has full legal validity, right? And this new e-title system, the land titles are provided immediately following approval by the land registrar. The landowner receives a notification with a link to download and save a digital copy of their title deed. Like, how cool is that, right? It's on their phone. And the system eliminates physical land title deeds entirely because it implements a zero trips, zero paper approach to land transactions. But then for us, as lawyers, what is really important is the legal implication that we get to see from this e-title system. Because firstly, after an application is approved by the Registrar of Land Titles, the landowner not only receives a notification with a link to download and save a digital copy of their land title, but that digital copy is actually an authentic, original, fully legally valid land title. So you don't actually need a paper a physical paper to show that you're the owner of a specific land. And then also that they launched their digital land registry where you can actually go and see a map of where your land parcel actually sits, right? And this basically eliminates the traditional waiting period for any physical title production. It also, does away with corruption and also, the manipulation of title deeds, because if it's going to be integrated with blockchain technology, you're able to see the chain of links and transmissions as to how this title is moving about. So it's a very secure, encrypted system, really, really important for certainty when it comes to home ownerships. And then also the legal, the electronic titles, they carry the same legal weight as physical certificates, right? Which enables their use across all sectors requiring land documentation, which means you can produce it as, collateral for banks. You can use it for obtaining loans as part of financial services. And also you can, the fact that it is now digital and you are, and say, for example, you owe the government taxes and you've not been paying, the government can actually put a tax lien on that particular e-title that you actually hold. So it's a very comprehensive, dematerialized sort of a transaction system that we're seeing in Rwanda. And under the new system as well in Rwanda, the landowners no longer pay, I think, about 5,000 Rwandese franc that they used to pay for printing their title. And also the land transfer, when it comes to commercial and industrial use, when you wanted to transfer land, especially within the commercial sector or within the industrial districts of Rwanda, that usually had to happen at district level. Okay, so you could be a company sitting in Kigali, but you want to move into the district, you've got to go and get this transfer done at the district level. You couldn't do it from the center. And of course, applicants were required to produce filled out land transfer contracts, proof of payment of transfer, notarial, fees that were equivalent to 30,000 Rwandese francs. And then they also had to produce the original land title, which showed commercial or industrial use, and also a lot of copies of identification of transferee and transferor. Those who practice conveyance, the heavy paperwork that has been.
There we go again. I think we lost you, Dr. Leila. I just realized whenever it gets interesting, we lose you at that point. So
I don't know. I'm at the university today, so the network is very shameful. I'm sorry about that. But generally, when you see the amount of paperwork that you do as conveyancing lawyers, now imagine there's no paperwork whatsoever. All you need to go is onto this platform and put in the name of the transferor and the transferee, the consideration, and done. It's basically waiting the registrar's approval for you to get your e-title. And it kind of eliminates a lot of paperwork, which means also the fees that we charge significantly go down. But the important thing is that the title is basically a one-day transfer system, sort of a title processing sequence. And it has resulted in unprecedented efficiency in property transactions. And at the same time, it has maintained legal safeguards. We don't need witnesses to accompany the applicants. The entire process is so simple because of the robust digital verification system that we have. And this is the system that also catches any manipulation when it comes to the tax that is required to be paid. It also gets information on who the true beneficial owner of this particular transaction is going to be, which basically works within the huge network of trying to combat illicit financial flows going forward. So I'm going to stop here and see if there are any questions and take it from there. I'm very sorry about the internet disruptions. I'm actually connecting now with my personal hotspot. Back to you, Rachel.
Thank you, Dr. Leila. Unsurprisingly, we only lost you at the point where it always got interesting. But we tried to hear most of it. And just for our audience to know, the presentations from your end will be made available. And this will be shared by the ELS Secretariat for you to actually catch up on this. I know that we are really losing track of time. So I'll encourage us to just drop the questions in the chat, or you'll raise your hand at the very end. You'll be given at least 15 to 20 minutes for you to be able to keep your questions coming in. I also have some of mine, but I guess I'll just ask at the very end. And I'm particularly excited for what's happening in Rwanda, hoping Uganda could also catch up next on the digital title system. So yes, I'll just go to our next speaker, and we've heard from each country perspective, that's particularly Uganda, Kenya, and Rwanda. So our next speaker will basically dissect the East African community, which involves other countries as well. And to this, we'll also be looking at what's happening with the Common Market Protocol in terms of taxation of real estate. So allow me to introduce our next speaker. And this is a tax professional who has previously worked with the Kenya Revenue Authority for about 25 years. And at KRA, he works with agriculture, energy, manufacturing, and excise duty sectors, among others. He also headed the transfer pricing audit sector, and he's currently an associate director with Deloitte and Touche in Kenya. So allow me welcome Patrick Chege, that is going to take us through the next session. And in this, we're going to be looking at cross-border tax strategies, navigating East Africa, community harmonization, and everything to do with real estate in the East African community. Please welcome Patrick.
Thank you, Rachel, and the audience. Let me start by apologizing because I'm not going to project my slides, but once I finalize them, I will share with everyone. So I'll be looking at the cross-border harmonization of real estate taxation across East Africa, and also the practical strategies for structuring cross-border property transactions, leveraging regional instruments to optimize outcome. So allow me to observe that East Africa has wide differences in their tax systems, and this manifests in the unequal treatment of taxpayers, also goods and services. And it necessitates the prioritization of harmonization of tax regimes of the member states. If you look at East Africa, look at the EAC trade, you compare it with the EU, we stand at 12%. That is the intra-trade among the East African countries stands only 12%. EU is 70%. You can see we have a headroom to cover for us to get anywhere closer to the EU. But one of the main challenge that is faced by the East African countries is basically the EAC double tax treaty, which is not yet implemented. As you are aware, a DTA is the instrument that would harmonize rates within a region or between treaty partners. And this DTA was negotiated many years ago. You may recall that the first version of the treaty was signed in 1997, and it was never operationalized. The second version was done, concluded in 2010. Still, it's awaiting ratification. I understand two countries, Burundi and Tanzania, have not yet ratified, and therefore the treaty is not in force. So allow me also to rush through, just to refresh your mind on some of the reasons why the implementation of the EAC treaty has not taken place, because you may be wondering what's the big deal, why not sign, and so on and so forth. But the fundamental issues and what has been observed is that some of them are in relation to economic disparities and even development. And if you look at in terms of development and economic disparities of East African countries, they are quite heterogeneous. There's a significant difference in the economic development levels, and this can lead to imbalance in trade and resource allocation. And this has been interpreted to mean that some countries may benefit more from integration than others, and potentially creating friction and resistance to further cooperation. Next is infrastructural deficiencies. Inadequate and poorly maintained infrastructure, particularly in transportation and energy, poses as a significant obstacle to regional trade and economic activity. As you know, infrastructure is so key. So where you have two countries with different development levels in infrastructure, then you expect trade to move towards one direction, and that may affect the other state very, very adversely. The other thing that has been observed is tariff and non-tariff barriers. That whole the EAC has made progress in reducing tariff barriers. Non-tariff barriers such as complex custom procedures, inconsistent standards, and restrictive regulations continue to hinder trade. I think this has been observed in the past, especially at the port of Mombasa, where goods sometimes take too long even to clear, and this has really impacted negatively on trade. And non-tariff barriers can increase the cost of doing business and limit market access for business within the region. Maybe something else to think aloud is the political will and cooperation. And here the success of regional integration hinges on the political will of member states to seek some degree of sovereignty and work together towards common goals. So disagreement on key policy issues, differing national interests, and lack of trust can undermine regional cooperation. The other thing to look at is overlapping membership and competing interests. And this is not just a problem of EAC, it is a global problem. You'll find that looking at statistics worldwide, almost every single country is a member of one or two trading bloc. So for EAC, some member states belong to other regional blocs like SADC, which can create conflicting obligations and dilute their commitment to EAC integration. Balancing competing interests and ensuring that EAC initiatives are prioritized can be quite challenging. We also have legal and regulatory framework where inconsistency in national laws and regulations can create confusion and impede smooth functioning of the EAC common market and other significant initiatives. Then harmonizing legal and regulatory framework across member states is essential for creating predictable and conducive environment for trade and investment. We also have implementation deficits where despite establishment of various protocols and agreements, the effective implementation at the national level often falls short of expectation. Weak institutional capacity, lack of enforcement mechanism, inadequate monitoring and evaluation systems also contribute to implementation gaps. We also have security challenges where transnational security threats such as terrorism, piracy, and cross-border crime can undermine regional stability and hinder economic development. Also, effective cooperation among member states is crucial in addressing these security challenges and ensuring safe and secure environment for regional integration. Then finally, we have social and cultural differences. This may not be very major, but also plays a role, especially in the East African in the East African situation. Now, looking at the EAC, let me call it draft DTA, and in terms of real estate taxation, you'll find in Article 6 a provision providing for income from immovable property, where Article 6(1) says the first rule that income derived by a resident of a contracting state from immovable property is taxable in the contracting state in which such property is treated. And this is basically this is normal for all the other DTAs that have come across, the ones that are in force in every country would provide for the same. It is the country where the property is located that would have the taxing rights. And then Article 6(2) would define the term immovable property, and this is normally assigned to the meaning under the rules of that particular state where that property is treated. So that, for now, is not a big issue because the DTA is not in force. Now, we can also look at some key rates for taxes for real estate sector in the EAC. And I'm going to concentrate on about four four taxes. We have dividends, and the reason why I thought dividend is one of those that would affect the real estate sector is because companies hold property, and the distribution of income on property to beneficial owners by companies is normally done through dividends, payment of dividends. Then we have interest. As you know, real estate is capital intensive, and most of the money will be borrowed, and therefore funding is an important component of this sector. Then we have stamp duty on acquisition and transfer, and capital gains tax on disposal of property. So EAC DTA is expected to produce uniform rates across the region, but this haven't happened. What we have seen is an attempt by some states to implement the reduced taxes for East African, residents within their domestic laws. For instance, if we look at dividends, we have a provision in Kenya that provides for 5% withholding tax for an EAC resident. We also have it in Uganda, again 5%. So it's expected that once the DTA is in force, for Tanzania, Rwanda, and Burundi, we also have a uniform rate of 5%. But right now, it is not there. What it means is that if an investor from Tanzania comes to Kenya, the withholding tax rate will still be 5% on dividend, even if there's no instrument for that purpose, because this has been domesticated. It is already in the income tax act, and that again would happen the same in the case of Uganda. So a Kenyan investor investing in Uganda, Rwanda, and Burundi will not have a preferential rate, and therefore that can be a disincentive to invest in those particular countries. But when you talk about the other non-resident withholding tax rates, Kenya has about 15%, Uganda 15%, Tanzania has a lower rate of 10%, Rwanda 15%, Burundi 15%. So when you look at that, they are more standard, except Tanzania that has 10%. And if you are to consider where to invest, holding other factors constant, possibly Tanzania will be a more attractive destination. But considering that we are in East Africa, then Kenya and Uganda may be more attractive than Tanzania, Rwanda and Burundi, because they don't have reduced rates, preferential rates for EAC residents. Again, all countries except Uganda, Burundi, and Burundi. So we're talking about Kenya, Tanzania, and Rwanda. They also have a 5% withholding tax on dividend paid by listed companies. I think that is more of attracting investment through those with lower withholding tax rates. Looking at interest, which is the second component, Kenya has very, very diverse rates, and they range from 15%, we have 7.5%, we have 25%, and we have 5%, depending on who the investor is or who has borrowed, who is being paid, the interest. So that is. If you compare that in Uganda, you have a start rate of 15%, than the borrowing by government or interest payable to government, which is exempt. Same case with Tanzania, but Tanzania has a 10% withholding tax rate. Rwanda has 15%. Again, interest payable to government again is exempt, but has a 5% EAC rate. So in terms of investment, if you had to look at East African countries, possibly Rwanda would be more attractive than investing in these other countries. Then come to stamp duty. Yeah, Kenya, we have 4% for urban land and 2% for rural land. So we have a two-tier system. If you have land in urban areas and you're disposing, then that would attract a higher rate of stamp duty. For rural, it's 2%, but it has some other capping, which we will not discuss right now. Uganda has a 1.5% only. Tanzania has a range of 0.5% and 1%, meaning that compared to Kenya, Uganda and Tanzania enjoys much lower rate and may be more attractive for investment compared to Kenya. But we don't have some duty in Rwanda and Burundi. So you can see Uganda and Burundi now edges Kenya, Uganda and Tanzania in terms of investment. But you can imagine, I'm not sure whether someone cannot just invest because of stamp duty rate reduction or has to look at other things. Yeah, when it comes to capital gains tax, again, Kenya has a 15%. Uganda has 30%, but for Uganda, this is capital gains is basically taxed as part of the other income, and therefore the rate applicable is corporation tax rate. Same case with Rwanda, again 30% on income. Tanzania, there are two rates of 20% for non-resident persons and 10% for resident persons, and Burundi 15%. And all these rates, of course, will have a meaning in terms of, in terms of decision making. So as I said earlier, what is expected is that once the EAC treaty is in force, the withholding tax on dividend will just be 5% across, and therefore no one country will have an advantage over the other in terms of that tax. Yes, in terms of interest again, when you look at Article 12 of the DTA, the EAC DTA, interests paid by a resident person, that is Article 11, to a resident of any other East African state may be taxed in that state, or in the state in which the company paying the interest is resident. So what we see here is that because there's a withholding tax, it means the paying country is likely to withhold the tax. And therefore, if that interest is taxable in the second state, it means the second state must give credit to the withholding tax that is paid in the first state. As I said, in Kenya, interest is so rare that, for instance, we have interest arising from government bearers board of at least 2 years duration, and interest and deemed interest, discount or no discount, has a 15% withholding tax. If you compare that with the interest and deemed interest arising from bearer board issued outside Kenya of at least 2 years duration, that has a 7.5%. About 50% of the first category. And then in respect of interest arising from bearer instrument other than government bearer boards of at least 2 years duration, we have a 25% again withholding tax rate. And finally, in respect of interest paid by the Special Economic Zone, SEZ, developer or operator, to an innocent person is just 5%. I think this data had even highlighted. Yeah. When you look at interest in respect of Rwanda appeared to be encouraging short-term borrowings from capital markets by reducing interest arising from investments in listed bonds with a maturity of 3 years to 5% when the listed company is a resident taxpayer of Rwanda or of the East African community. So this possibly hopes to encourage cross listing on the capital markets in the respective East African partner states. So in the context of taxation, the cost of capital is high in Uganda and Burundi compared to Kenya, Tanzania, and Rwanda. Yeah, so the implication of the ratification of the EAC DTA by Uganda and Kenya is that residents of respective states would pay higher taxes in interest from government securities compared to their counterparts in the community. That is an observation that has been made, which is likely to impact negatively, to investors in Kenya and Uganda. Maybe the other thing I would like to highlight is capital gains tax, and this is gains from disposal of shares, which are also taxable in the contracting state, which the person disposing the share is resident. And we have also already observed that some of the EAC countries do not have a decent capital gains tax because they tax the income with the rest of the income at corporation tax rate. We have seen the case of Rwanda, we have seen the case of Uganda. Then, of course, in Kenya, CGT is moderate. I'm not going to repeat what Rera said because that's a fact. And there are also very many exemptions in Kenya, as has been highlighted. Let me also not go over that again because it doesn't add value. Yeah, but overall, in terms of CGT, if you were to advise your client on where to invest, then it appears that Kenya and Burundi have more attractive rates, which is 50% and are more likely to attract investors compared to other treaty partners. Then, but Kenya, Rwanda, and Burundi are more favorable for equity financing by means of takeovers, mergers, and acquisitions because of the exemptions provided under the domestic law. So in terms of stamp duty, Kenya has the highest rate of stamp duty at 4% that we have gone through. Rwanda and Burundi does not have stamp duty. Uganda, Tanzania, lower stamp duties than Kenya. And from a stamp duty point of view, Rwanda and Burundi are the most attractive, for Kenya is the least. But when it comes to advisory US lawyers, I think it goes beyond just these few taxes. When you're considering investment, all relevant factors must be considered, and not just dividend, interest, CGT, and stamp duty, even when it comes to real estate. Besides relying on comparative taxes across East Africa region, one may also look at the treaty networks concluded by states. State parties with other partner states outside the EAC. A case in point are the DTAs with Mauritius and UAE and other low tax jurisdictions because they offer very attractive rates. So if you invest from there, maybe to say to Kenya or any of the East African countries where there's a DTA, where they have concluded DTA with Mauritius or UAE, you are likely to benefit more or benefit your client. But this must be subject to the limitation of benefit clause because I think this is a game changer. Under the DT, and I think this has also been introduced from the OECD point of view, is that you cannot benefit from a treaty benefit if you're not a resident of the treaty partner. So I am aware there is a case already in Uganda. There's a dispute finding its way to the courts on whether a person who is not a resident of a treaty partner can benefit from a treaty benefit. So other considerations that you may wish to also look at is the ease of doing business, then political stability, maybe aggressiveness of the revenue authority, and other macroeconomic factors like market size, inflation, and foreign control. Yeah, I think I'm done with my presentation. I hand it over to the Secretariat.
Thank you very much, Patrick. That was quite timely, actually. We finished exactly at apportion time. And I've already noticed that there's a question for you, but we'll take this at the end so that we can maximize the rest of the time that is left. We still have 2 topics to go. And now that you've just given us a glance at the East African community, and taxation aspects in relation to that, it's time for us to actually look at the legal professionals that are present. I think as you're concluding, you also directed a question to them and talking about how they should approach tax advisory and different transactional advisory. So this is going to actually usher us into our next topic, where it's going to bring a legal practitioner or tax practitioner for that matter, a very big tax guru in Uganda, who has also previously worked with the Uganda Revenue Authority. And he's going to give us strategic pointers on how a legal professional can actually position themselves. I'm excited for his topic because I know he also introduces certain aspects or certain nuances in what we're seeing at the tax scene, especially on the green economy and sustainable finance and all that. So please allow me welcome Mr. Birungi Cephas, and he's the founder and currently managing partner of Birungi Barata, a law firm in Uganda. He has over 35 years of experience in tax and 20 years in the legal profession. He's previously worked for the Ministry of Finance in Uganda, that's in the early 80s. And he's also worked with the tax regulator or tax authority, as I already said. He's been ranked as one of the best tax lawyers in Uganda. That's at the global scene. And he's also worked with global players like the World Bank, the International Finance Corporation, and with different sovereign states. Please allow me to welcome Mr. Cephas without any further ado, so he can just speak to the legal professional that is on call on how you can strategically position yourself to advise your clients. You're welcome, Mr. Birungi.
Thank you, Rachel. Can you hear me?
We can hear you.
Thank you. Good afternoon, everyone, and thank you all the previous speakers, Patrick and Lyra, for the wonderful presentation. Today, I'll talk about the real estate area of business. I'll give an overview. Then we'll talk about real estate investment trusts, and then affordable housing incentives, green building tax credit, and then discuss strategies. I'll not really be giving any big leads, but I expect people to respond. So in one or another, this is kind of a question and answer session, the last part about strategies. Thank you. So yes. So real estate, I'll take the definition from the Capital Markets Collective Investment Scheme regulations of Kenya and the regulations of Uganda. They have a useful definition of what real estate is. They are the laws which are specific to real estate. If you look for a definition of real estate in the Income Tax Act or in the VAT Act or in the Stamp Duty Act, you'll not find it because those laws are not focused on that scope as real estate. They have other specific definitions of that area. So the collective investment schemes laws, rather specifically the definitions, the regulations define real estate as all things which are natural part of land or growing on the land, attachments above and below the land, and things which are fixtures or are developed, installed, or constructed on the land, including buildings and site improvement. The definition also includes improvements in permanent buildings, plant, equipment, attachments such as plumbing, heating, cooling, electrical wiring, and built-in items such as elevators, and all rights and interests attaching to the land. So it's quite wide, but it's important for us to have it as a starting point, especially when we are talking about the real estate investment schemes, which will be part of our discussion. But also it's important to know that this is also important when in income tax, when we are talking about investment allowances, capital allowances. So some of these items, which are plumbing, heating, cooling systems, are part of the capital deductions. So they might be important in different aspects. So that gives us a foundation of what is real estate. When we bring it down to simpler terms, then we know that we are talking about our homes, improvements on the land, which are natural or artificial. But it's also important to know that real property differs from personal property, which is not permanently attached to the land. So things like vehicles, boats, jewelry, furniture, farm equipment are specifically excluded from this definition. Might be also important to distinguish between real estate and real property, because the two have some nuanced distinctions, which are important for us when you are looking at the real estate investment trust, because some of the properties under real property do not necessarily qualify under real estate, because real estate mainly is physical objects and what is attached to the land. So for tax purposes, it becomes important to look at, bring it down to what anybody sees on the day-to-day and know that, yes, a residential house is a dwelling place, but it can be a taxable item. How is it taxable? An industrial plant is a real estate, but is also subject to tax in different ways. A commercial building attracts tax in different ways. So each of these have a different aspect of taxation to them, and they have got to be looked at specifically. For example, if you are looking at residential, it could be important for income tax as income of the owner of the residence. But it can also be important for VAT in terms of it not being liable to VAT. So that becomes a planning area. But it can also be liable to VAT when it is residential and it is, say, a service apartment. So each of these is looked at. One has to look at it in very different and nuanced ways. So when you invest in real estate, most of the time you have commercial real estate, residential real estate, short-term rentals, and developed land. These are known by almost everybody. These are the common things. You have a commercial property, people are renting from you, you have offices, you have shops, so you may have industrial buildings, which you rent out, and those are commercial real estate. You might have residential rental properties, which are rented as homes or family units, apartments, condos, etc. You might have one which is a residential property, but is also specifically a short-term rental and is a service apartment, or it is an Airbnb, and the tax person will look at it differently from how another residential property is looked at. So each of these can have different aspects to it. Or you could have undeveloped land and you are holding it as an investment, and you have a way of flipping it around and selling it as land or parceling it out and still selling it and doing business. For today, we shall have a special emphasis on what is called real estate investment trusts. And this is another way of doing business. And specifically, we shall go into some detail what it is. The Real Investment Trust is in Uganda regulated it comes under the law called the Collective Investment Schemes, and then it has a regulation under that law. So the Collective Investment Schemes law came into effect in the year 2003, so it has been around for some time. But as you can see, it took on about 14 years for the regulations to come out. One wonders how. So the Real Estate Investment Trust is called an arrangement in respect of real estate or real interest, or rather real estate or interest in real estate of any description structured in accordance with the rules prescribed by the authority to enable person taking part in the arrangement, whether by becoming an owner of the property or any part of it, or otherwise participate in or receive profits or income arising from the acquisition or holding, management, or disposal of real estate or interest in real estate. Quite a long definition. By the time you are through with it, you are not very sure where you are or what it was all about. But basically, when you analyze it, it means that investors pool money and invest in a trust with the intention of earning profits from real estate as beneficiaries of the trust. So in order to understand it, you look more at the characteristics and exceptions rather than the long definition. So the real estate, the right, as we are going to, the acronym we are going to use, the right, sources funds to build or acquire real estates, which they then sell or rent and generate income. The income generated is then distributed to the shareholders at the end of the financial year. They operate income-producing real estate or related assets, which may include among others, office buildings, shopping malls, or apartments. So the main thing is that different people pool money together. You need to have an unincorporated entity trust, which is divided into units. You then establish under that a trust deed. You must have a trust deed. You must have a trustee who should be independent of the right. You need to have a manager, and you need to have a promoter. So basically, it is a regulated transaction. It is a bit different from the other instruments we looked at earlier. If I am a property owner under residential, there's no need for the government does not define how I should build the house for me to be a property, just a house owner, or a commercial property owner, or an industrial property owner. But if I'm in a right, then each of the aspects of ownership are specifically defined. So that's the distinction between it, and that is why we need to see this as a different instrument, which has been on our drawing board for a long time. And that graph, the chart ahead of you, shows the structure which is provided by the law. You must have a unit holder, you have the right in the middle, you have a trustee, you have a portfolio of authorized investments, you have a right manager, and you have a promoter. So this is specific. It is different from any other ways of doing business in real estate. So there are different types of rights as provided by the regulations. One of them is called the D right, which is Development and Construction Real Estate Investment Trust, and it focuses on financing and construction of new real estate projects. The developers utilize D right to raise capital for large projects and then build different types of investment. The regulation requires that for you to do a D right, you need to have a minimum value of assets, initial assets at the time of starting, of 250,000 currency points, which is equivalent to 5 billion shillings in Uganda. The other type of right is called an income right, and it is designed for properties that generate consistent rental income. Basically, it means that here you are investing in things which are already in existence. So you buy properties while in the other one, you are actually constructing and raising the properties. And then in Kenya, for example, they have also an Islamic rite. So so when you look at it, the structure in East Africa, you find that in Kenya, they have 4 registered rights. Uganda has 0 registered right. Tanzania has 1, Rwanda has 0. So when you look at a situation where this Collective Investment Schemes Act came into place in 2003, and the regulations came into place in 2017, you wonder how you can have this law in place and nothing has actually happened for all this time. So what are the questions behind this? And what are the challenges? So you see, there are challenges, maybe. Of course, not very many studies have been conducted in this area to know why there has been no uptake. Normally, you would expect that the policymaker, when they are starting the law, has seen a demand for a product. So in this case, you wonder, was this law preceding the product? Who is supposed to follow who? If the law came into place, why has there been no uptake? Or why did the policymaker make the law when there was not enough demand for it? But anyway, that being the case, you find that one of the studies in Kenya, it is found that the high cost of entry of about 100 million Kenya shilling for capital requirement might be limiting participation. And of course, that may not be a big problem for banks, but you'll find that in many of these cases, if you look at the Collective Investment Schemes Act, it has very many products, including unit trusts, umbrella trusts, which, for example, in Uganda have very big uptake currently. And you find that many small investors have put their money in these umbrella trusts, which are also under the Collective Investment Schemes Act, but are different from the rights. So maybe because of the ease of entry into these instruments, most of which come from through circles, people have found it easy to invest. Because when you look at the rights, you find that you then need to have a big development project, you have a structure, managers, developers. So that might be one of the reasons discouraging entry. The other is the lengthy approval process. When you look at the regulations are 236 pages. And most of them are about procedure, this procedure, that procedure at every stage. So they require a lot of study and careful study, and they need a lot of approvals by the Capital Markets Authority. It is also very likely that there is low investor awareness, because when you look at it, you know that, for example, in Uganda, there have been attempts by a few people, a few individuals, to create the kind of estates which would be envisaged by this law. A few companies bought a lot of land and used their own money and parceled out pieces of land and called upon interested parties to develop small cities. But the 3 I know seem to have had serious problems, and possibly it is because they were not very well structured. They were mainly running on the whims of the one person who developed the idea. And when these individuals ran out of steam, most of these projects collapsed. So it might be important that if there was serious awareness, maybe this investment option could have been more developed. But you see that also in Kenya and in Tanzania and Rwanda, this has not been a very successful project. In fact, when you look at the statistics, you'll see that 99% of the people who are into construction still use the traditional funding from the banks. And when you compare with the developed countries, you find that only 40% use the banks and 60% use other instruments which are specifically designed for long-term investment of this nature. And that's why you find that many of these building projects around don't last very long. They end up in foreclosures in the banks because there's no specific safety net for them. So when you look at this, you find this graph tells you that even the capital market, the Kenya's capital market for the real estate sector is significantly low at 0.1% or less compared, say, to Australia, which has 5.7%, UK 4%, South Africa 1.9%, and UK at 1.8%. So these other countries in West Africa would be at a pure 0%, not even 0.1%. So in terms of taxation, one has to look at the different aspects. Of course, we have income tax and all these taxes which the previous speakers have exhausted. The capital gains, the rates have all been talked about. But it is important for lawyers in this case to note that, yes, what are the key drivers? What does one look at which is a distinguishing factor? Which areas are the gray areas? What are the gray areas that need specific advice? As one of the presenters said, we have a withholding tax on sale of business assets. And there is a withholding tax for both residents and non-residents. But then you find that the definition of a business asset is not clear and has remained one of the gray areas. Is it a business asset in the hands of the seller? Is it a business asset in the hands of the buyer? That is not well defined. So the URA always finds that there are gray areas and people are called upon and they then have to prove that whatever was sold is not a business asset. But again, this is related to the capital gains tax, which has been ably presented by both Claire and Patrick. The point is that whereas Uganda has a capital gains tax which appears to be flat, 30% and included in the rest of the income, there are other distinguishing factors because if the real estate, the rental tax is segregated from other tax, then it is specific on rental, it is silent on the capital gains. It is silent on the sale of that property. In fact, the portal doesn't even provide for it. If I own rental income, rental properties, which are just for residential purposes, and I sold them, the law doesn't envisage having a capital gains, but it is silent. So it appears to be more of an omission than a deliberate move. And then you have the sale and leasing of removable property other than service apartments being exempt from VAT. This item is in respect of the VAT. So generally, the VAT law says if you are having residential properties, normal rental properties, there shouldn't be a VAT on that. But it then makes exceptions about service apartments. And this has been one of the contentious areas because service apartments are not defined. And even if they were defined, it would need a lot of specifics to confirm what qualifies. Is it if I have a fridge or I have a washing machine? Is it what kind of thing qualifies as service? Then we also have in the sale of property, especially in VAT, a provision which says sale of an improved land is not taxable. And also, again, here you find that improved land is not defined. So it is an area where the lawyers have got to be involved in this, the jurisprudence of these areas. You also have hybrids where you have Airbnb, then you have properties which may be partly residential, partly commercial, or partly service apartments. Those are all gray areas where the lawyers need to be at the forefront and see that the law improves. Time is running short, but it's important, again, to look at, when we go back to the Real Estate Investment Trust, to see that Whereas, for example, in Kenya, there has been a lot of effort to exempt investments in this area, whereby income tax is zero, VAT is zero, stamp duty is zero, share transfer from SPVs at zero. Still, there has been very little investment, meaning that tax alone is not a good enough driver for some of these. It must come from the people. In Uganda also, the income of collective investment schemes is exempt to the extent to which that income is distributed to participants in the collective investment scheme. Therefore, the Real Investment Trust scheme, shareholders, if they received their payments, would be exempt from this tax. But whereas this applies largely to the SACCO incomes which are in Uganda, when you come to rates, there is still no investment, so nobody has taken up this offer of investment. When you go across your different jurisdictions, you'll find South Africa and the US also have been specific to exempt the incomes for when the dividends are distributed. So whereas you find that people seeking investments and the state has said we are giving exemptions in respect of foreign investors who invest up to $10 million. If there is such a big exemption for persons who are investing 5 billion, minimum requirement of 5 billion, and they are not liable to pay, there are virtually no taxes, one wonders, are they not investing because this area has no return, or are they not investing because there is little awareness of this opportunity? Of course, we assume that as lawyers, you should be able to advise some of the investors who come to you. I know very well that many investors come knowing what they want to do, but I also believe if there is more awareness about these opportunities, possibly we could have more investment in this area. The other area which we require to mention briefly are the affordable housing schemes. And Lyra mentioned that Kenya has got a big incentive, especially with the current president who campaigned on the wave of affordable housing schemes. And there are a number of incentives for all taxes. But interestingly, Kenya seems to be the outlier in this area as having this scheme. We do not have an affordable housing scheme incentive or even any mention of that or a definition in the Ugandan sphere. So it is an opportunity from the EAC presentation like this for the policymakers to think of these kind of opportunities which are definitely very much in demand, which would be very much in demand everywhere. Tanzania also has a preferential corporate tax rate for affordable housing, which includes a VAT relief of up to 100 million Tanzanian shillings. Rwanda has a flat rate of 15% for registered investors in low-cost housing. We do not have low-cost housing guidelines or definitions in Uganda. In other words, Uganda is lagging behind the rest of the East African countries in this area. I know that it must only be a lapse on the side of the politicians because they would have quickly launched into this. It would be a bigger opportunity than some of the other programs which are very much highlighted. The other area of this topic is the green building, sustainable, the energy incentives through taxation, which are called green buildings, where you have eco-friendly buildings, environmentally friendly buildings, getting tax incentives or tax credits or tax deductions. This is a feature which is common, which is there in Kenya, 100% tax exemption on interest income for bonds and securities used to raise funds for green building projects. It is also an easy thing to copy from countries like Singapore, which provide property tax rebates when you have a green mark gold rating for green investments. It's common in India, it is common in Singapore. So our policy makers should look at this and try to bring new instruments. So what are the opportunities for the lawyers? The opportunities include areas of legislative drafting, because you can see this is an area which is quite virgin. It has been around, but a lot still needs to be done. This is a highly regulated sector, and you have to have many lawyers. Even if there were just 5 projects, they would engage very many lawyers because it requires a lot of administrative legal work. You need to look at the 236 pages of the regulations to know that there are many opportunities. This presentation, talking about cross-border disciplinary teams, I believe many persons who are listening in, having listened to the experts, especially the 2 from Kenya, must have noted that there is a lot they could learn from each other. How I wish the policy makers could also learn from this opportunity. And how I ask Gabriel and team that we should have a paper presented in a common newspaper such as the East African, which is capturing all these differences and all these gaps and asking, why has this not been done? As Patrick said, the DTA has been on the drawing board for more than 15 years and nothing has been done. No questions have been asked. So with the lawyers, we have the normal activists who are supposed to be banging the tables. And this is one of the areas in which we should be not this silent, and we should point out very clearly what are these salient gaps which should have been exploited. I believe the lawyers in-house or who are listening in must have noted that there are gaps which they can exploit. So we need to have a wider discussion on cross-border right structuring. We need to have discussions about assisting clients. We need to have discussions about harmonizing tax policy and managing multi-layered compliance requirements. Of course, from Deloitte, you must be getting requisition inquiries about cross-cutting issues. Lyra talked about the deemed disposal provisions in the Ugandan law, which are quite harmful to investment. And the question is, how did this kind of policy come in? It has been around, it has been sharpened every other time. Why do we have it? Why would we have an instrument like this, which appears to bring very little in terms of tax, but chases away a lot in terms of tax? So I hope these discussions are of some use, and I thank you for listening to me.
Thank you very much, Mr. Birungi. I hope I should have hoped we had more time for us to dissect. You had quite interesting topics that I wish we had more time to look into, but maybe to the ELS Secretariat, this calls for another session to look at some of these topics specifically and go back to them or revisit them. Yes, so I'll just, without any further ado, I'll go to our last panelist of the day. I know our time is fast spent, but please accommodate us for the next maybe 25 minutes and allow us invite our last panelist. This is a representative of the Uganda Revenue Authority today. He works with the Uganda Revenue Authority as an acting manager of the appeals litigation. He's not new to many of us, especially if you've been anywhere around the Tax Appeals Tribunal and the higher courts in Uganda, and you've probably witnessed his passion in tax. So today he comes to speak to us about the digital economy and taxation of the digital economy. This is also one of the trending areas, and it's been trending for a while, of course. But most importantly, to note that at least the East African community has validated some of these proposals in taxation of the digital economy and also generation of revenue from other new areas like the green carbon credit taxation of the green economy as well. So please allow me to welcome Tony Kalonji. Mr. Kalonji, over to you. Too bad that we may not have so much time, but please take us away.
Thank you, Rachel, for the introduction. So without further ado, let me share my screen. Yes, so yes, so I'm going to be presenting about digital tax platforms, the opportunities and challenges for lawyers. I'm going to focus on the digital tax platforms we have in the ESC. Particularly, we'll have those, what we call the e-tax in Uganda, Tanzania's ePortal, and then the Rwanda's RRA platform. Then we'll see how these are helping to reshape the real estate compliance and the stamp duty processes. We'll look at data privacy concerns and any system inefficiencies. And then we'll end with the evolving role of legal advisors. So briefly, these systems are used when it comes to perfecting transactions in the real estate sector. I'll focus more on URA's e-tax, but basically whatever has been presented by Cephas, let's say when you look at investing in the real estate sector, there is a compliance arm to it, whereby you need to pay taxes and even regularize these transactions. And to do that, the e-tax or the digital tax platforms are used. For instance, if you look at financial institutions, you look at the mortgages. How are these mortgages perfected? You realize it's perfect if it is registered with either as a security either on the land or on the company's assets floating and fixed. Then you get to insurance companies who will have insurance policies, land, how you will transfer the said lands. There are some documents we do to perfect inaccuracies in things we have defined before, affidavits and certain declarations. You'll have stamp duty payable there. There are those transactions we have to benefit from estates of deceits. So you'll have letters of administration, then you'll have asset financing, then you'll have issues of bonded warehouses. So in all this, we'll use the digital tax platforms to see, but I'm going to focus on stamp duty and Uganda's e-tax. So if you look at stamp duty, basically, it's a revenue that is payable on every instrument. Normally, instruments will be those documents that are based on to perfect the transfers or the securities. So it is mainly fixed duty, whereby you find it's either 15,000 or it can be ad valorem, where you're given just a percentage to pay depending on the subject matter. So in Uganda, briefly, I thought I would take you through the process so that we see the role that lawyers can play. In Uganda, when you are looking at perfecting these that have a fixed rate, the system is simple. We have what we call the URA portal, where you go and do everything from there. So ordinarily you log in, you make a declaration in that portal. After making that declaration on the same portal, you print out your declaration form and you'll get what we call a payment receipt number, whereby you pay it and you get an acknowledgement form. Then after that, okay, that one, after you're done, you go to the same URL and they give you what we call a barcode. Now, after the barcode is given and put on the document, they print for you a stamp duty certificate, which you can also do yourself from the URL portal, or if you go to the URL offices. You will find, just try to shift this. You will find that when it comes to instruments that pay an ad valorem rate, that's where the system it becomes a bit manual. The reason for this is that when it comes to valuations, if the rates are specifically provided like 15,000, it becomes easy. But when you go to ad valorem, it's not enough for you to just insert the value. Processes of validating this particular value come into play. It could be, for instance, let's say we are looking at the perfecting a transaction of RECs that Cephas has looked at. You could indicate that the value that is in that instrument is maybe, let's say, 1 million shillings. But it's possible that that transaction could be accompanied by other documents that it's not unusual for a person to front one document instead of the rest. So they look at all the documents and they see which one will possess the actual value. So here also the process is the same. You go to the URL portal, make the declaration, you print it out, you get an acknowledgement. After the acknowledgement, you present it to the URL officer. Now, it's the URL officer at that point who looks at it and gives you an assessment, which you go and you pay in the bank, and you come back and they deposit it on the instrument, give you a barcode, and they give you a stamp duty certificate. Now, specifically for transfer of title to land, the process also becomes a bit unique. Previously, the system was 50-50 online and manual, whereby previously you would go and log in, and then you will have to go and walk to the Ministry of Lands. You go to the Chief Government Valuer, who would look at your transfer form and write for you there the value. You bring it back and URL bases on it to assess for you the ad valorem value. However, currently, the system has been developed and the systems have been linked. So you find the Ministry of Lands is linked to the URL portal. How? Currently, when you go to and make a declaration to the portal and you get an acknowledgement, you can scan these documents and attach them therein, so that it's possible for the Chief Government Valuer to base on them to give you the actual value. However, the practice of still doing the manual way still exists, whereby people go to the Chief Government Valuer and try. And the reason for this is that the methods of valuing the land by the Chief Government Valuer are not yet computerized. The Chief Government Valuer has discretion to decide which particular value to give you within a specific range. So it's not unusual for people to go to the Chief Government Valuer and try to reason that this particular transaction you're looking at for transfer of land, I actually have proof to have bought it at this, or the land is not so developed, or it is, let's say, on a slanting hill, and for that you should give it this value or not. So after that is done, then you go back to the normal process. If the Chief Government Valuer attaches the value, you present the declaration form, the application for the transfer and the consent. The URL officer verifies, because ad valorem involves verification. After they have done so, that you make the payment in the bank, and then you go back, they give you a barcode, you print a certificate. So basically, that is it. However, we'll have instruments that are in foreign currency. And for that, the rule is you base on the exchange rate that is on the date of execution of the instrument. Ideally, that should be easy, but I see some controversies there. Because if you're to base on the date of execution of the instrument, it could be that some people might argue that had the transaction happened at a specific date, they would have paid another rate. So for that, we are yet to have a dispute on this, but we just choose to convert and we use the rate of the BOU. However, the digital platform eTax is also linked to SaveView. You need not go to Bank of Uganda or read the newspapers. What you do in practice, you go to the URA portal and the exchange rate will be there. Yes, so we have compliance requirements. In Uganda, non-compliance with the Stamp Duty Act, for instance, if a document does not pay stamp duty, and the document needs to be relied on by third parties, they are prevented from relying on it. For instance, courts of law, that document will not become admissible. We have had several cases in Uganda where you find the dispute involving land is settled on whether or not stamp duty was paid. And someone's certificate of title is cancelled because the stamp duty was not paid or the value at which it was based was not proper. So it is very crucial and can affect the entire real estate sector, because it's taken that non-payment of stamp duty can lead to the transaction being illegal. It can be fraud. It can also be an error on the face of the record. Then if documents are not stamped, if you don't put the barcode or if URA does not certify, they are not approved to perfect the transfer of title. Then the law gives powers for people to impound these instruments. You present your instruments for transfer before a public office and they are not duly stamped with AG land, they can hold those documents and not return them to you. Then also it is an offense, but you pay a penalty if you're convicted, which is just 100 currency points. That's 100 times 20,000 to be just 2 million Uganda shillings, or you can be imprisoned for 6 months or both. So compliance is important. However, I was supposed to also discuss data privacy concerns. Yes, there are scenarios where they can arise, because essentially, whereas these documents are between inter-parties, it's possible that information can get into hands of other people. For instance, the eTax system is linked to other government bodies like ministries of land who have their own system. However, it is designed in such a way that only officials of those respective bodies get access to see. So this is to limit any issues of someone's documents or transactions leaking. Then also, the officials themselves are bound by the data privacy laws in Uganda. No, they are not supposed to disclose this information. However, the system, in my view, has some inefficiencies, especially when it comes to this idea of valuation. From a tax collector's perspective, who aims to collect more revenue, from the side of the pie, it's not weird for me to suspect that people push for the lowest value within the range of values, and this is caused by the fact that if you look at valuation of land, the chief government valuer has a lot of discretion to employ a lot of methods that can lead to a range. So it's not cast in stone that property located in Kampala should be valued at this specific amount. Now, under our tax laws, if you look at the rates we charge, let's say for collecting of rental tax, there is a schedule that the minister had issued to say for properties located in this specific range, we're supposed to charge this amount. Then also, if you go in the another arm of taxation, let's say customs, where we have a specific valuation methods under our East African Community Customs Management Act of transaction value, of then go transaction value of identical goods, go to similar goods, go to the deductive, computerized, and then fallback method. This valuation of the real estate is not something that is clearly elaborated. So you find that those are the inefficiencies when it comes to ad valorem valuation, because you just need to go to the chief government valuer and they write their value for you. This value, they need not make a report, those of you who deal in banking, that is done by, let's say, valuers, where they give you the market price or the first market value. They just indicate the value. So because of that, it's inefficiency in the system. Yet if the system was designed in the way whereby if you're going to pay stamp duty and you go to the URA portal, you click stamp duty, you reach where, let's say, the land is located. If you're to sell, let's say, Kampala, automatically they go ahead and ask you which part of Kampala and they locate it. I think it's not hard to connect that system to, let's say, other systems of, let's say, Google Earth, to say that that land, depending on the measurement, we expect it not to exceed or to be exactly this amount. So because of that, you find that a system that is totally online, it needs the physical form to go to a chief government valuer to sign. However, there are talks to develop these processes to make sure that the values that the chief government valuer keeps on using are embedded in the system. So if the chief government valuer has always valued land in Kampala, let Chibuga block this and that, they should be able to insert the values and make those values work for a specific time, unless they go high or they go low. This will make the system so efficient and stop the paperwork and even some ideas that seem to be either values being too high or too low. Those are the inefficiencies. Now, the roles of a lawyer, I'll try to be fast. Most of them, Cephas have talked about them. So when it comes to understanding tech-driven tax compliance, lawyers also play a pivotal role because they are the ones who interact with these laws and they are able to analyze them and provide the relevant gaps and areas to improve, provide proposals to policymakers to make the laws or improve them. Then also they can integrate these systems. You realize taxation of the real estate involves many players. There will be lands, there will be those in Ministry of ICT, there will be the URA, there will be those in charge of registering the tax collectors. But lawyers have a pivotal role because they can quickly analyze and integrate these laws. So when it comes to also the politics around it, lawyers can play it. At the end of the day, there is legislation we need. And since these are laws that are passed, lawyers are the best policy makers, in my view. You find that the process of making a bill necessitates it to go before a legal committee somewhere to be considered. Then also, I talked about the process in which they are involved in, whereby they can even challenge the law and correct it. For instance, in Uganda, we are trying to charge stamp duty on advocates that are renewing their practicing certificates, but the Uganda Law Society was able to challenge that decision and stamp duty was ideally set aside, that 100,000. So there is something they can play. Then they can act as tax representatives. It's not unusual for people in the banking sector to only focus on banking and lending money. And when it comes to perfecting securities through mortgages or any transfers, they normally outsource this role to advocates who can carry on these duties of the stamp from the point of preparing, certifying any returns, and so much so. Then tax education, which we are doing now, they do it. Then dispute resolution, they act on both sides. In case a dispute arises in the real estate sector, you will meet me or someone on the tax collecting side, and then maybe, let's say, Cephas on the other side, or Patrick. Then also tax administration, you will meet us there, mostly lawyers. Then tax planning and advisory, Patrick sector, you'll find that normally lawyers are the best, and also Lila's areas of tax education. So briefly, I don't know which way I've been too fast, but because of time, without being a mouthful, that's essentially how digital tax platforms provide opportunities and the small challenges for lawyers. Thank you.
Thank you very much, Tony. I think this session particularly required perhaps 4 hours, but in cutting it short, probably we'll have another session, and I think Gabriel has taken note of that. But thank you very much. That was quite insightful and quite fast, but we'll try to pick a few things here and there. And in the same breath, I wish to extend my sincere appreciation to all the panelists. And just before I get talking through this, I will take some questions from our audience. We have someone with their hand up, and then I'll also take some from the chat. So there's Teresia. I don't know how the other name is pronounced, whether it's Cash or Cache or whatever it is. Teresia, please go ahead and unmute and ask your question. Teresia, are you there? Well, as Teresia probably gets ready, I will take some questions from the chat, and I'll start with probably the last question. There's a question from Cleophas saying, ELS team, thank you very much for organizing an informative and engaging webinar on taxation, as particularly enlightened by Senior Counsel Birunji's presentation, especially on insights shared. So he has a clarification on the following scenario that he would like to seek. Assume a situation where my property is mortgaged with a bank. However, due to high, sorry, am I losing this? Okay, so sorry, there are messages that keep coming in, so whenever they come in, I sort of lose up. Yes, so I'll just go back to the question, and he says, assume a situation where my property is mortgaged with a bank. However, due to the high interest burden, I opt to sell the property to a third party, and the proceeds from the sale are used to clear the outstanding mortgage loan with a bank. In such a case, is the transaction subject to withholding tax, considering the funds are not retained by me, but directly go towards the loan? Just invite Mr. Birunji to respond to this, or to any other panelists that also might want to chip in there.
Thank you, Rachel, and thank you, the person who asked the question whose name was difficult to read. But in a transaction where the money, the tax law normally looks at each transaction as a separate transaction. Ideally, when you do this, Tony will come to you and say you sold, there should have been a withholding tax, and the tax is supposed to be withheld by the payer. The person buying is supposed to withhold, and it's not supposed to be bothered whether or not you have a mortgage. But in the specific case you are talking about, and I believe Tony will highlight using the case of Lualua and others, where the money is actually taken through the bank, the question is whether you are actually capable of withholding, because this buyer is paying the bank. So if the buyer attempted to withhold, the bank will say that what you have paid is not enough. So there is a practical aspect to some of these transactions, and we have also seen this in a number of banking transactions which are called nostro charges. Similar concept, not necessarily on land, but the question is how would you actually withhold from this person when you are paying to their bank? But the principle is this is a different transaction, you should withhold. The question to me is how would you withhold? Thank you.
Mr. Birunji, I don't know if there's any panelists that probably would like to support on this. I'm very cautious of the time, and I know we've pushed with over 10 minutes, but there is also another question, and I think this was generally put to the panelists. And the question is from Peter Wangondu. I hope I pronounced that well. So the question is, how do legal practitioners, how would they navigate the complex web of withholding taxes, double taxation arguments, and harmonization efforts when advising clients on cross-border property investments within the East African community? This is quite a broad question, but I invite you panelists to give it a go and see what we can address.
Rachel, can I take that?
Yeah, sure, Patrick, yes, please.
Yeah, it's quite an interesting question from Peter. And when it comes to lawyers advising clients, I think the most important thing to know is that you can only advise a client based on the existing law. You have seen that for over 20 years, we've had a DTA for East Africa, which has never taken off. That means you cannot advise a client based on a prospective law, the law that is to come, you don't know when. So it must be clear that if you want to invest in a country, you have to look at the law existing as at that time. And therefore, you look at the laws that are enforced and are impacts on the transaction at the time of advising. And I think in the advisory, I always see lawyers writing that this advisory is based on the existing law. Should the laws change, this advisory may not be valid. So I think that is as simple as that, unless someone wants maybe an advisory that is prospective, that's what if this DTA is put into force, then what would be the benefit of us investing in a certain country or certain region? But advisories are normally based on the current or the existing law, given that you don't have control of the governments when they shall incorporate, or operationalize laws that have been suggested, laws that are not in force. So possibly that's my thinking about that particular question.
Thank you very much, Peter. I also see a comment in the chat box from Dr. Leila, where she's also giving guidance on how you can go about this from a legal perspective. So Peter, feel free to also take a look at that. And I don't see any other questions that we have, except that the audience is quite happy with the presentations that we've had. Tony, there's an appreciation to you on the presentation, and I've been seeing several coming forward for all the panelists. Thank you very much for taking the time to dissect some of these topical discussions for us. We'll see how we close this in the next 1 minute, and we'll of course not close without extending our sincere appreciation to the Secretariat. We also request that perhaps another session be considered where we can dissect some of these topics further, because there's so much that is happening across the region, and would need us to come back together to learn from one another. Just to say that the presentations will be shared by the Secretariat. So just rest assured knowing that we'll have the presentations from our panelists. And in case you have any questions or would like to interact further with each one of them, please feel free to reach out, because their contact details will also be shared along with their presentations. So thank you very much. Thank you, panelists. Thank you, ELS Secretariat, and thank you very much to the audience for accommodating us for over 14 minutes beyond the set time. Thank you for also staying longer. We appreciate you, and until we come back again. Thank you. Yes,
Thank you, Rachel. Our esteemed panelists, it's really been an honor to host you once again this afternoon on behalf of the East Africa Law Society, our Secretariat, our CEO, Mr. David Sigano, and our President Ramadan Abubakari. We would like to thank you for your selfless sacrifice of being here and sharing your knowledge and expertise with us. We greatly appreciate that, and may the Almighty God richly bless you and continue to be an example and light to the community. To you, our esteemed participants, we would like to thank you for being here with us for the last 2 hours. It's actually over 2 hours now. And I hope that we have all learned and taken a good notes with the topic. As has been requested by Rachel and the panelists, we'll plan to have another session discussing this very topical issue, but also we anticipate having a similar session during our annual general meeting that is coming up in November. So I encourage all of us to attend in large numbers our annual general meeting that will be happening in November this year. So we'd like to thank you. We'll also take into consideration the proposal by Senior Cephas Birungi on having such articles carefully set out in our regional papers, but also nationally. We'll work towards that, but also be on the lookout for our East Africa Law Society bulletin that will be coming up, and we'll be sharing some of these wonderful insights in the bulletin. But that said from us, we wish you a very lovely afternoon. A recording of this session will be shared to your different emails alongside the presentations that have been made this afternoon. And we also invite you to join us on Thursday for a discussion on capital markets and securities. It's a discussion that you would not like to miss. So we thank you so much. Thank you, our esteemed panelists, Mr. Kalunji, Mr. Birungi, Mr. Chege, Dr. Laila, and to you, my good friend, Rachel Kembabazi, for sparing your afternoon and speaking to us. We wish you all a very blessed afternoon until we meet again on Thursday. Goodbye, and we may now exit at leisure. Thank you.
Thank you, Gabriel.